Okay, it's about 8:30, a little after 8:31. Uh, it is Wednesday, December 5th. Welcome to week 10 of Introduction to Corrections. I told you that the quarter was going to go really fast. Quarter ends next week, so I'm going to take time to go over some things, and then I'll give you some parting remarks. So let's go ahead and get started right away. Share my screen. Okay. You can see the information down here that you're familiar with. Then you see the recordings. Today we'll have week 10 at the end of this. And let's look at the announcement for the week. We're going to talk about juvenile offenders. You read chapter 13 of the text. I provided you with the PowerPoints. Then a little bit about the juvenile justice system, some perspectives, major cases, and then some vocabulary. And then remind you that your initial post, the role of juvenile PO or probation officer, was due on yesterday at 11:59 p.m. Central Standard Time. Your reply post is due Saturday, 11:59 p.m. Central Standard Time. Your written assignment, your state's waiver process, and the quiz are due this Sunday, 11:59 p.m. Central Standard Time. Okay, so let's take a look at the calendar. Okay, and you can see this is where we are here. And you click on that, you see the reading assignment there, your initial post, your lecture now, your reply post due Saturday, and then Sunday, your quiz and written assignment. Now remember, I always recommend that you take the quiz at the end of the week. Some of you decide to take it earlier, but I always recommend that you go over the material before you take the quiz. And then next week, because this is it, you have your reading assignment, then you have your initial post, and then next Friday, the 14th, reply posts are due, written assignment, and then you have your final exam. That will be due on next week, 14th. Okay. Anything that comes in after the 14th is not going to be graded, so you should be aware of that. All right, let's go to Module 10, and let's look at the assignments. Okay, so let's look at what the rubric calls for. Very important to follow that. So conduct research concerning your juvenile process and transfer. 2 pages. 2 pages. Include statutory sections, well-written paper, minimum of 2 pages. Be sure you run your papers through Grammarly. And then, of course, citations in the body and references in the end. Roman font 12 point should be used in all papers. Okay, and that's the written assignment. Then, let's go back. Your discussion post. Then, of course, your quiz. Okay, so that's what you have in terms of assignments. So let's go into the module itself, and let's get the lecture going here. anyway, we're going to talk about the juvenile justice system and the objectives here. We're going to talk about the system, historical perspective, and then close with the juvenile corrections vocabulary. So the juvenile justice system, you should be aware, is different from the adult system. The idea of the juvenile justice system is operating on the basis of the juvenile being treated as a child, and the court operates as the parent. The British term used parens patriae, which allowed the English kings to intervene in the lives of children. And so the juvenile courts do the same thing, working together with the parents. And there is some similarities in the juvenile justice system as the adult, but the process doesn't start with an indictment or a summons, but instead with a petition. And that you should know the vernacular. Juveniles are not arrested, but they are taken into custody. Now, for all practical purposes, it means the same thing, but what it is the language indicates the direction that the juvenile court goes. It's not punitive. It's more rehabilitative. And so that's the essence of it. And then, again, as I said, the court steps in to correct the individual or provide services or things that can help the individual. So a person is taken, youth is taken into custody, detained, but not jailed, adjudicated, but not found guilty, and given a disposition and not a sentence. So the key thing is to soften the process to indicate that you can get the feel of what is taking place here, is that the juvenile is, as I said, more coddled, or should I say use the term, again, it's rehabilitative. That's the bottom line from the very beginning. And that the, again, repeating that the court steps in to operate as the parent of that child who has been taken into custody, detained. And if they're adjudicated, then you give them a disposition. And usually that disposition has something to do with until that child reaches 18 years old, if it's a serious offense, or either the individual is given a lighter sentence there. So there is the same process in adult court as in juvenile court relating to probation. And what happens is the probation officers provide, they're almost like a social worker. And there is an investigation report, or what we call a PSI, pre-sentence investigation, and it gives the background of that juvenile, and it helps the court to determine the proper disposition, since there is no sentence. And juveniles are classified based on their risk and needs, and given programs and services to help, as I said. And the juvenile probation officer works very closely in the instance of juveniles with the family. Juveniles can also, it says, be placed out of the home, in residential placements, group homes, wilderness programs, boot camps, and secure detention. You see, once again, the idea is to teach a lesson to that juvenile. And educational resources are made available also. And also, if there's some drug problems, then they also should address those as well. It says when a juvenile offender, though, is recidivist or commits heinous crimes, they can be waived into to adult court, which means that they will be taken out of the juvenile justice system and tried in the adult court. And most states have a waiver system, and it can result in serious adult sanctions, including prison. And so, because of the fact that youth are involved in a lot of crime, some serious crime, it results in much of the overcrowding, the violence in prisons. And then those juveniles who are placed there are open to learning bad habits, exploited by the adult offenders who may be their lifers or be there for extended periods of time. And so many states try to use that as a last resort, and sometimes will place an individual in house arrest or put the individual on electronic monitoring. That's just a little bit. So now let's look at the major cases that take place in the juvenile justice system and a little bit of the history. Starting in 1966, how the juvenile justice system has evolved in Kent versus United States, where the court held that the court must provide due process in transferring juveniles. So in other words, they must have a hearing, they must have the ability to be able to cross-examine witnesses and provide reasons why they should stay in the juvenile justice system. So it's not like an automatic transfer. There is actually a hearing that takes place. And Kent established that in 1966. The following year, Galt, Henry Galt, another landmark case, which says that commitment has basic rights, that right to timely notification of the charges, the right to confront witnesses, the right against self-incrimination, and above all, the Sixth Amendment right to counsel. And so these are things that came about considering the due process rights that were given in 1966. But now these are the rights that are given, whether it's transferring or not. It's the rights that's given in every juvenile adjudication that every juvenile is entitled to under the Constitution. In Winship, in delinquency matters, there is a standard of reasonable doubt, not preponderance of the evidence, so it's the same as in a criminal charge, even though, remember the purpose of it, but it's still a violation of criminal law, so therefore the standard is the same based upon Winship. McKeever versus Pennsylvania, there is no jury trial constitutionally required in juvenile court hearings, and the reason is because of what I said earlier, that the court steps in and parents patriot and looks after. Now, of course, if the individual is transferred to adult court, then they do have a right. But if they remain in the juvenile court system, then there is no right to a jury trial. And the thing there is to protect the privacy of the individual, and then also at the same time to, again, give the courts more control over the disposition to help that minor. Reed versus Jones, waiver of a juvenile to criminal court following adjudication following a adjudication in juvenile court constitutes double jeopardy. So in other words, if an individual is tried in juvenile court, you cannot then transfer them to adult court and try it. You don't get two bites of the apple. It is a violation of the Constitution, double jeopardy clause, and that's what Reed versus Jones stands for. In other words, the prosecution doesn't get two bites out of the apple. Smith versus Daily Mail Publishing has to do with the press and the responsibility of the press reporting juvenile court proceedings and they have to be very careful. They usually redact the name of the person. They will use John Doe or some other an acronym or name other than that individual to protect the identity of that juvenile. So they're allowed to report, however, very limited in how they give out the information. Eadings versus Oklahoma, a defendant's youthful age is considered mitigating factor in determining whether to apply the death penalty. Now, I'm giving you history now, because when we get to 2005, you're going to see that that's totally resolved as of 2005, and I'll reserve that until we get there. But back in '82, the age of the minor is considered strongly in determining whether to apply the death penalty. That was in '82. Remember that. So moving ahead to '84, you see again in Shaw versus Martin, a 1984 case, preventive pretrial detention of juveniles is allowed. In other words, it means that they're not entitled to bail or to be released, but can be held during pretrial under certain circumstances. And it probably operates the same way as adults, based on the seriousness of the offense, based upon whether the individual is a repeat offender. Thompson versus Oklahoma, and here we go, says the minimum age for death penalty is set at 16. Once again, I'm giving you history. So now let's go to Roper versus Simmons, which resolved in 2005. The minimum age for a death penalty is 18. So what that means is that juveniles cannot be given the death penalty no matter what the crime, no matter how serious the offense is, as of the decision by the United States Supreme Court. Again, remember, we're trying to salvage individuals, the juveniles, and so the death penalty is considered, in a situation like that, cruel and unusual punishment. It is considered something that cuts against the grain in terms of the goal of the juvenile court system. So those are just a few historical landmark cases for you to keep in mind. But always remember the death penalty case, because that's a big one here. And so finally we come to the vocabulary, parens patriae. I told you that. That means that Latin term where the English kings established the right to intervene in the lives of children. That's what the court does now as well. Then juvenile delinquent. This is a minor who violates the criminal law or is truant or runaway or incorrigible. Status offender. Juveniles who engage in behavior that is illegal only because of their age. Only because of their age. Community treatment. The efforts to provide care, protection services, and treatment to juveniles. Remember, I was talking about that earlier. Probation, counseling, restitution. The key thing is to teach that juvenile a lesson. Try to salvage that juvenile if possible. Institutional treatment, facilities operated by the state and the county, restrict the movement of residents through staff monitoring, locked exits, and interior fence control. This is the kind of facility, one of the kind of facilities that juveniles go to that involved in serious offenses that are not transferred to adult courts and to prison. Residential programs, social services, group homes, family group homes, wilderness programs, boot camps. In other words, to try to scare those individuals or teach them lessons to try to salvage them. Non-residential programs, they are not confined overnight but allowed to go home. Same kind of things before. aftercare, almost like parole, where after the person is released and they still have time in their sentence, they're under the control of the juvenile probation officer or someone in that similar role. Judicial waiver, this is the process intake where prosecutors or judges make a decision to change that individual or move them into adult court. So I talked about that earlier. Social investigation report, that's the same as PSI, where predisposition is given, the background, the history of that juvenile as far as the criminal justice system. Statutorial exclusion. In certain states, automatically transfer juvenile offenders to adult court for certain offenses. Now, that's very interesting. You got to, if you check those, you are probably going to discover that they're very, 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 very severe offenses, and that there's no place in juvenile court for those individuals in terms of correcting them. Therefore, it's been the decision of some states to send those individuals. I would look for those to be challenged because of the goal of the juvenile court. In other words, the due process aspects. So if there are no due process aspects in place to automatically transfer, which I would presume that the automatic transfer does involve some due process, and if it does, then there will probably not be any constitutional challenges to it. And that's the end of that. Okay. So that's it. Let's go take a look at Module 11, since we will not be having a lecture. So I can just kind of like tune you in on what you got to do the final week. Okay. So technology in your correctional system, again, there's the rubric that gives you and tells you that's due Friday the 14th. And the rubric here tells you it's a 1 or 2 page paper. Make sure you run your papers through Grammarly. Well organized citations and references. Okay. And then your discussion post, challenges for professionals, and then your final exam. Now, what's the best way to prepare for this? My recommendation is to go back and look at the PowerPoints that I gave you to help you because of the fact that the PowerPoints give you an outline of the material in the course itself. I know it's 11 weeks, but I've been talking about this since week 1. And so remember, this is a 40-minute test, and you should abide by the academic misconduct policy. That is, you should not have materials in front of you and doing that. We can tell because it depends on how much you complete. So you again, remember, one of the issues that I've talked about from day 1 is integrity. And you got to be that, and then you got to be ethical. If you're unethical as a student, I already said this before, sound like a broken record, you'll be unethical as a student, as a professional, and that will land you in a bad situation. So that's it. I do want to say that I have enjoyed teaching this class. Many of you will discover, again, if you get the dream of the very first week, which I tried to do very seriously in the open house, of what the essence of this course is, corrections, and giving you the 4 sections, which are jails, prison, probation, and parole. If you picked one of those four and you decided to do first week, it's only 4 modules for week 2, week 4, week let's see, week 7, and I believe it's week 9. I know week 9 is the last one. So the point of the matter is that's a big part of this course, and it should help you. It's more like a field report to give you an opportunity to learn how corrections operate in whatever area that you chose. And I did encourage students to make sure that they picked an area that they would be interested in, or either one they already work in, where they want to make their careers in. And so it is something that would benefit you. Remember, as I say to students all the time, the assignments we give you should be a part of you. In other words, you should look at the assignment not as completing it to get a grade, but completing it to learn more about the field and area that you are entering into in criminal justice. And even if you're going into law enforcement, you want to learn corrections because you want to understand how that works. And do understand that there are 2 different goals in criminal justice, in corrections, and in law enforcement. And a lot of students get confused there and want to try to do their projects in this class on law enforcement. And I say you can't do that. This is a corrections class, Introduction to Corrections. So anyway, I've tried to help as many of you as I could. I try to make sure you understand how to use Grammarly, very important tool, and checking the plagiarism box, and also reminding you of the requirement of APA, citations in the body, references in the end, cover page, Roman 12.5. And that's the way papers should be. That's the way students should submit their papers in order to maximize their grades. And so, again, I wanted to say I'll see some of you probably in other courses. Usually in this course, I see people next quarter. I'll be teaching this course again, but I'll also be teaching contemporary issues in criminal justice. That's at the end. And then I will be teaching drugs and crime, J250, and 150, Introduction to Criminal Law as well, where I'll see many of you in the next course. So I wish you the best. If you have any questions between now and the end of the quarter, you know how to reach out to me. I've already laid that out consistently, letting you know, and some of you have taken advantage of that. So it's been a pleasure teaching you, and enjoy your evening, and I'll see some of you in the winter quarter. Good night.